Yes. So in terms of sources of company law, first, statute law is a source of company law. And in that regard, as far as our jurisdiction Ghana is concerned, the principal legislation regulating the company law is Companies Act 2019, Act 992. So Act 992, to a large extent, constitute about 65 to 70% or so of company law. And if you look at that legislation, so at this stage, I expect that you have your Act 992 by your side. If you don't have it, I'm giving you 30 seconds, try and grab it.
No, no, 30 seconds.
Yeah, so have your Act 992. So if you look at section 1, subsection 1 of Act 992, for example, we are told that the legislation, that Act 992, applies to all companies in Ghana formed before or after the commencement of the Act, which is 2nd August 2019, because the Act is deemed to have, it was assented to on 2nd August 2019. So from August 2019 coming, the provisions we have in Act 992 is the governing law. And again, if you look at Section 2 of Act 992, please look at your law. Section 2 of Act 992. Somebody should read it for us, just to make sure that we are on the same, we are working together. Somebody should read Section 2 for us. You don't have your law, okay. So Section 2,
okay.
Chapter.
Prof, I read.
All right.
Okay. Section 2. The Act does not affect the validity of anything done before the date when the Act comes into operation. Application of particular chapters. 2.1. Chapter 2 applies to all companies. Chapter 3 applies to private companies. Chapter 4 applies to public companies. Chapter 5 applies to external and non-Ghanaian companies.
Okay, so Section 2 is giving us the picture that, yes, Act 992 governs companies. However, we have different types of companies, and there are certain aspects of Act 992 which apply to some companies and do not apply to other companies. So let us keep that in mind. And again, if you look at Section 4 of Act 992, specialized companies are subject to additional rules, despite general provisions of Act 992. So we have specialized companies, such as companies set up doing banking business, companies doing insurance business. These are specialized businesses, and oftentimes there are regulators, and these regulators would actually have some additional requirements. So we take banks, for example. We have the Banks and Specialized Deposit Taking Institutions Act, 2016, Act 930. And that legislation, for example, create additional rules for companies that are banks. So if you're a company and you are doing banking business, it's not enough for you to be set up under Act 992 and start running a banking business. You must also bring yourself within the framework of the Banks and Specialized Deposit Taking Institution Act. Now, it is also pertinent to appreciate that the Gowers report, I'm sure you might have heard of something called the Gowers report, or you're wondering what it is. Okay, so just a brief thing for you to appreciate. Before we came to have our Act 992, we used to have what we call Companies Code, 1960 Act 173. We used to have that legislation. And how did that legislation come about? Now, the first president, Dr. Kwame Nkrumah, commissioned a scholar called Professor Gawa, who was assisted by our own VCRAC Crab, of blessed memory, to look around the world in African countries and try to make recommendations for a new company legislation which will serve the interests of Ghana. So that culminated in what we call the Gowers Report. And then the Gowers Report is actually a proposed companies bill with commentary on various clauses of the bill. And it was that bill which was eventually enacted as the Companies Act 1963 at 179. So it was that bill. Now, because of the comprehensive nature of the report and the effort made by Gawa to explain and comment on various provisions of the bill, which was eventually passed as at 179, for a long time, the report was seen as an important aid. If you say aid, that is a material which provides assistance to help the court to interpret or to understand or to expound the provisions of the Companies Code, which emanated from the Gowers Report. Now, that Companies Code, which has been repealed by Act 992, in terms of its substantive provisions, are largely reenacted in Act 992. And for that matter, the utility or the usefulness of the Gowers Report to the old Act 179 is still relevant to the new Act 992. And again, if you look at the Interpretation Act of 2009, Act 792, it permits the use of report or commission of inquiry, in which case the Gowers Report is an example because it was what they call the Gowers Commission. So it permits the use of a report or commission of inquiry in the interpretation of statutes. And of course, the Companies Act is a statute. So if there is ambiguity or lack of clarity regarding the scope or the or proper interment or import of a particular provision, the court can have recourse to the Gowers Report and find out whether there is any relevant commentary in relation to the particular provision of Act 992, which needs to be interpreted. And in fact, we have examples of case law in which the court actually made use of the Gawa report to interpret the act. So if you look at the case of Politis and another against Plastico Limited, number 2, Justice Amisa sought to interpret section 185 of the repealed Act 179, which has now been reenacted as at section 176 of the current Act 992. I mean, the same wording, or as lawyers would say, is in pari materia. Now, Justice Amisa alluded to the Gawa's report when it became necessary to interpret this particular provision. You can also look at the case of Okujeto. I'm not talking about the current Okujeto Blackwell. Okujeto against Imani Brothers. The same reference was made to the Gawa's report in trying to interpret some of the relevant provisions. However, in the case of Adams against Tando, the Court of Appeal made the point that the fact that the Gawa's report could be resulted to did not mean that the commentary which the commissioner had made on the relevant provisions was binding on the court. And of course, I mean, that is true, but one will also appreciate that that particular decision predated the enactment of the new Interpretation Act of 2009. Now, what is the relationship between the Companies Act, Act 992, and other statutes for special business? In other words, where there is a conflict, somebody has left his or her television on. Can you please put your mic off? See the person. John, Sylvie.
Sir.
Yeah, I'll put your mic off. Okay. So what is the relationship between the Companies Act, Act 992, and other legislation or statute for special business? When there's a conflict between them, which of them should hold sway over the other? Well, as a general principle of law, the provisions of a special statute takes precedence over provisions of a general statute. So we call that the lex specialis derogat lex generalibus, meaning that if you have provisions of a special statute, or specific provision, it will supersede provisions of a general statutes. Therefore, if we look at section 4 of the Companies Act 2019, Act 992, it gives preeminence to special regulations of a general provision of Act 992. Somebody should read section 4 for us to confirm what I have just said. Maybe yes, anybody?
Okay, Prof, section 4, I read. Companies formed for special purposes. Section 4. This act does not abrogate or affect legislation relating to companies carrying on the business of banking, insurance, or any other business which is subject to a special regulation.
Good. Yeah, so that is it. So, but Act 992 does not abrogate or take away the efficacy of the special legislation as we have mentioned. So therefore, the banks and specialized special deposit taking institution legislation is saying something which is contradictory to the Companies Act, that will hold sway over the Companies Act. So please look at the cases of George Cohen against Comet Construction, and then the case of the Republic against Jamestown Circuit Court, Judge S. Party Ano. Again, we need to remember that despite having elaborate provisions in Act 992, the common law and rules of equity are still part of our company law. And for that matter, if you look at Section 5, it will make the point that the rules of equity and of common law applicable to companies shall continue in force unless they are inconsistent with the provision of this act, unquote. In other words, all that the common law and equity provided, as far as company law is concerned, still remain part of our company law, insofar as they are not contradictory to the express provisions of Act 992. And for that matter, if you look at Section 217, right? Section 217, for example, Section 217 is part of the provisions relating to directors. Later on, when we are doing corporate governance, we come across that. Now, Section 217, in speaking about duties and rights of directors, will make a saving and say that the common law and equity is still relevant. So if you look at Section 217, it says that the rights, duties, and liabilities of officers and agents of companies shall continue to be governed by the rules of the common law and equity relating to principal and agent and master and servant, except insofar as those rules are not inconsistent with the express provisions of Act 992, unquote. Yeah, so that is an evidence of the position we articulated earlier, that rules of equity and common law are still part of what? The company law. The only caveat is that they should be compatible with our Act 992. So the question arises whether Act 992 is a codification of existing corporate rules of equity and common law. Can you really say that? Can we say that Act 992, that is the Companies Act, has codified the rules of common law and equity relating to companies? Well, I will let this be a rhetorical question at this stage, because as we journey forward, you think about it and then provide an answer. Another source of company law is the judicial decision or case law. So here we are talking about rulings by the courts, interpreting and applying provisions of the legislation to concrete facts and practical problems facing corporate world and business. Again, case law or judicial decisions which predated Act 992 are also considered as part of our company law. So for example, if you take the seminal case, the landmark case, or the celebrated case of Solomon and Solomon, which deals with the separate legal personality of a company and its limited liability, is the cornerstone principle of company law. And this was decided way back 1897. So it still forms part of our company law. And I asked you, when I met you in class, and then I asked you to read Solomon and Solomon. I want to believe that you have read it. If you haven't read it, I'm urging you to go and read Solomon and Solomon before we start discussing the concept of corporate personality. Again, so just to, in case you did not need my advice, Solomon and Solomon, that case was about a man who had a private business, a sole proprietorship as a leather, shoemaking guy. Later on, he decided to register his business as a company and gave, I think, 1 share to each of his 7 children and then the wife, and all the other shares were for himself. And he also sold his shoe business, his leather business, to the new company. And the new company had not finished paying him. So the rest of the price, he decided to treat as a debt which he had in the company, which the company owed him. In the course of time, the business of the company ran into difficulties, and then it was collapsing. So other creditors which had done business with the company and the company is owing them decided to sue and to ask for the few assets of the company to be applied to pay off their debts. But Mr. Solomon also jumped ahead of the queue and also said that they are not the only people the company owe. He was also owed by the company. And in fact, he was one of the important creditors of the company because he was even a secured creditor and all that. Now, the creditors with an argument that Mr. Solomon should not be entertained because he's behind the company to outsmart creditors of the company. So his claim should be disregarded. So it was there and then that the court had opportunity to reflect on the legal implication of actually incorporating a company and came to the conclusion that when a company is incorporated, it attains or assumes a separate legal personality from the incorporators. And in the eyes of the law, it is a separate legal person. So despite the fact that the business, which had changed its character as a company, was actually Mr. Solomon's business, in the eyes of the law, it was separate. And for that matter, if it owed Mr. Solomon as a person, nothing prevented him from pursuing his claim against the company because it was a separate person in the eyes of the law. Similarly, the case of Trevor against Whitworth also propounded that a company share capital be kept intact for the benefits of its creditors, or what we call the doctrine of capital maintenance, which is a very important doctrine in corporate finance, that if you have a company and the company has raised capital by issuing shares and all that, the capital so raised should not be dissipated. It should be conserved for the good of the company. Now, we've also mentioned company theory as another source, and here we are just talking about various academic texts, the reports of relevant commission and legislative working papers as another useful source of understanding company law and its various dynamics. So, what is the proper function and role of company law in economy? In other words, when you are trying to mobilize company law for effectiveness, what are you really seeking to achieve? What is the role, or what is the proper function of company law in economy? Well, three approaches exist in the literature or among scholars regarding what the proper function and role of company law should be. So, one approach says that company law should be facilitative. That is what we call a deregulatory approach. And that simply means that company law should be primarily that of enabling those engaged in commerce to order their affairs in whatever way that suits their best purpose, with minimal interference from the state. So company law should not be too prescriptive. Apart from minimal ground rules, companies should be given a lot of room to make their own choices and their decisions, as it were. Now, those who hold this view are actually thinking along the lines of the principle of freedom of contract. If you remember your contract law, laissez-faire economy ideas, which says that adults of sound mind and so on should be at liberty to make their own choices through contractual arrangements. So in the same vein, facilitative or deregulative approach says that legislation on corporate matters should be very liberal so that the company can have the freedom to decide on many matters that relate to governance and running of the company. So the state, through legislation on companies, should not lay down too many rules, too many prescriptions for the company. Rather, the company should be given a lot of room. So, going by this facilitative approach or regulatory approach, the thinking is that most of the rules or the provisions of the company legislation should be default rules so that they will become applicable only where the company concerned fails to provide for them in their regulation. In other words, just as, like we have default settings, all of us are computer people or technology people. We have default settings in your phone or in your laptops. But you can change the default settings. You can customize it as you want. So in the same vein, those who say that the role of company law in economy is facilitative or argue that if you have company legislation at all, they should be such that if the company decides not to provide what it wants, then certain things have been provided already and they will apply to the company. So look at the Companies Act. Well, because if we had time, we don't have enough time tonight, but having told you this, I'm giving you a short assignment. It's not assignment that you're going to submit for marking, but at our next class, I will ask you to give me 5 examples, right? Give 5 examples of provisions from the Companies Act 992, which actually show that those provisions are more facilitative in the sense that the company can change them, but the company is not really bound by them. Well, usually, if you look at the legislation, where you see may, then you say that the company may, or this may. Now, where you notice that in the provision, they have used the permissive word, the modal word may, what it means is that it's elastic. There's that flexibility. The company can make the requisite changes or adjustment as it wants. So that should help you to get some of the examples from the legislation. On the other hand, if you see like SHA, you know SHA is imperative or is mandatory. So that way, you have no choice. You have to do what the provision says. Now, the other approach is what we call regulatory or prescriptive approach, which is the opposite of all that I've said regarding the facilitative or the regulatory approach. That there should be more elaborate regulation of how affairs of the company should be run, so as to forestall possible abuse of the privileges incidental to incorporation. Now, those who postulates the regulatory approach, they are coming against the background of a certain historical experience that if you look at the history of company law, especially in England and Wales when it started, there was a time that some people manipulated and abused certain concepts and brought about a whole scandal, including the South Sea bubble scandal and all that. And for that matter, we're saying that companies should not be given free hand to do what they want. They abuse the opportunity, they abuse the freedom. So rather, you must lay down a lot of ground rules to check potential abuse. Now, those who subscribe to the regulatory approach says that rules of prescriptive nature can be used to make the company a powerful instrument of social engineering and supplementing the law in such other areas as labor and environmental law. That, for example, when it comes to corporate governance, if you subscribe to the regulatory approach, you can actually direct the company on what the company should do for good of society, for good of the environment and all that. When it comes to mining, for example, companies in mining, they make their profit and then they probably don't think about the environment. So if you subscribe to the regulatory approach, you make prescription regarding what percentage of their profit should be used to, for example, do certain environmental initiatives and all that. So the regulatory approach favors the company be giving very little or no matters over which it can exercise its own initiative or freedom. Now, if you look at the legislation, oftentimes where the modal verb shall is used, it is indicative of the fact that the company is obligated. It has no choice, has no discretion in the matter. So I would like you to also run your eyes through the provisions of Act 992 and identify at least 5 examples which will suggest to you that the Company Act is being regulated in some respect. Then we also have like the middle way approach. Those who hold the view that company law should not assume any of the 2 extreme functions. It should not be seen as being facilitative and for that matter heavily deregulatory. It should not also be seen as being prescriptive and for that matter heavily regulatory. Rather, they take the view that it's like a continuum. So you should pitch it in the middle. In some respects, it should be prescriptive. In other respects, it should be regulatory. So you merge like the 2 approaches. So that is a middle way approach. Now, having said that, I promised you it was going to be an hour's class. So let's make some quick progress so that I'll release you. Go to work tomorrow. And okay, let me do it this way. I think tomorrow, if you have the time, tomorrow, 6:30, if that is fine for you, we can actually have a class. Maybe your prefect will let me know if that is fine for you. Okay. So because I promised we'll do this up to 9, it's 9:05, I'll leave you. And then tomorrow we'll continue. So have a good night.